Hello to everyone, and thank you very much for joining us today for this panel on Article 6, Authorisations and Adjustments, what you need to know and what is still unknown following the COP26 decision in November of last year. My name is Hugh Salway, and I am Head of Environmental Markets at Gold Standard. When the gavel went down on the Article 6 decision in the final hours of COP26, there seemed to be two main channels of thought amongst onlookers and observers. For some, there was a sheer sense of relief that after 6 years after the Paris Agreement was adopted in 2015 and after two full starts at COPs 24 and COPs 25, we finally had some clarity on Article 6 rules. For others, though, there was a sense that for all the questions that have been resolved, just as many remain unanswered. Questions like, how in practice will governments make decisions on whether to apply a corresponding adjustment? When will they be ready to do so? What will the distinction between adjusted and unadjusted units mean for the market? And a big one for many of those listening in, what does all of this mean for the voluntary carbon market? So in today's panel, we're going to cater to both of these perspectives. We're going to dive into what was agreed at COP26, as well as what still needs to emerge, whether that's through further negotiations or through the implementation of Article 6 by governments and by others on the ground. We're going to focus in today's webinar on two of the elements that sit at the heart of Article 6. Firstly, the decision by a government to authorise emission reductions for use by other countries or entities. And this authorisation effectively means that they give up the right to use those same emission reductions towards their own NDCs, and they're available for use by others. And then second, the application of a corresponding adjustment by that government. Now, corresponding adjustment is the accounting tool that the government needs to use to follow through on their authorisation and to make sure that reductions are only counted once. We're really honoured today to have a really brilliant panel joining us to dig into all of these issues and to let us know what was decided at COP26, what are the remaining things that still need to be resolved, and how we're going to get to where we need to get for Article 6 to genuinely contribute to what we need to do on climate change. So firstly, I'd like to welcome Molly Peters-Stanley, who I think may be a little bit late, but has hopefully joined us or is joining soon. Molly is Negotiator for international carbon markets in the US State Department, and she leads the US's involvement in Article 6 negotiations, as well as being chairperson of the technical advisory body for CORSIA. Secondly, Mbaye Diagne, who amongst other things is Director General of Afrique, Energie, Environnement, is lead coordinator on carbon market issues within the UNFCCC for the African Group of Nations and is a member of the CDM Executive Board. Thirdly, Lambert Schneider, who is research coordinator for the Oeko Institute on International Climate Policy, is a member of the CDM's Executive Board and is co-chair of the expert panel of the Integrity Council for the Voluntary Carbon Market. Fourth, Marisa Martin, who is an executive director at Pollination, an investment and advisory firm focused on the transition to net zero. And last but definitely not least, Lisa DeMarco, who is a senior partner and CEO of Resilient LLP and is council chair of IETA, the International Emissions Trading Association. So welcome everyone, welcome to our panel. And before we start, I'd just like to provide a few instructions for those who are watching the webinar today. We're going to hear from our panelists shortly who are going to give some introductory remarks, and then we're going to open up for the questions from you, so the questions which you have burning and which you want answered. So as we go through the webinar, I'd ask and encourage you to write questions into the chat box, and then once we've heard from our panel, we're going to try to answer as many of these questions as we can in the time that we have afterwards. But first, I'm going to turn over to panel members, and let me just come off my screen. And I see that we still don't have Molly Peters-Stanley. So what I'm going to do is I'm first going to turn to Mbaye Diagne, who, as I mentioned earlier, was a key representative in the Article 6 negotiations representing the African Group of Nations at COP26. And Mbaye, there are many on this call who saw the Article 6 outcome at the end of last November, and I think are very interested in what happens next. So what will this mean for governments, how will governments then translate this into action, and how will they start to make decisions on when they will use Article 6, when they will apply corresponding adjustments? It'd be really interesting to hear from you, your perspective on these questions.
Thank you, and good afternoon, dear colleagues and friends. I'm very pleased to be with you today to discuss what needs to be done from a host country perspective when it comes to this authorization when participating in Article 6 activities. First, we need to understand that because activity we are talking about in relation to Article 6 are many of them part of countries and NDCs. So because of that, there is an obligation to report at the UNFCCC on the implementation of those activities under the enhanced transparency framework, because we need to report on the implementation of our NDC, and that includes these international transfer mitigation outcomes and all Article 6 activities. That is first. But we need also to stress in the current decision on Article 6 that whether activities are inside or outside a country's NDC, they can be transferred with or without authorization. But in the case that transfer need an authorization from the host country perspective, a corresponding adjustment is needed. That is very important to stress that. It's for activities for which, whether they are inside or outside countries NDC, when they have an authorization from the host country, they will need a corresponding adjustment. We need also to stress that units internationally transferred may come from the Article 6.4 mechanism, but they can also come from many other standards, including gold standards, VCM, VERA, or bilateral agreement that generates units or mitigation outcomes. There are many ways to generate those units. But any of those ones, when internationally transferred with an authorization, need to meet all the guidance we have defined under the Article 6.2 guidance. That means that the participating countries in that transaction must meet what we call in the guidance the participation responsibilities. There are some responsibilities each participating party must meet before being allowed to have this transaction. In those participation responsibility and what the participation party must ensure, there is having the arrangement, the institutional arrangement for authorizing this use of UTMOS towards NDCs or other international purposes. We need to have this institutional arrangement. And that we need also to have in place the arrangement to track the ITMO you transfer and to report back on that. That is the minimum you need to have. The institutional arrangement to authorize, but also the institutional arrangement to track and report back on what you have done when it comes to ITMOs. But to authorize now, when you come specifically on the authorization, you need first to identify which within the country institution will deliver this authorization. Which activities, depending to sectors, type of activities, volume of units, you will authorize for this international transaction. Some country may choose to take the higher abatement cost activities, only those ones to be internationally transferred. While some others can also consider that the low-hanging fruit can be part of that. Some country can choose, if they have conditional and unconditional NDC, only dealing with market with the conditional NDC, while some others may choose whether the conditional or the unconditional, bearing in mind that in any case, if the authorization is provided, you will have the corresponding adjustment. We need also, and it's a requirement, to have a trajectory of your NDC, whether you are in multiple year or single year. And when you are single year, you may choose to have an average, but in any case, you need to have this trajectory, whether it is an average or you build it, because many countries haven't clearly defined the trajectory. You need to do it. You need also to put on place procedures and process for the validation, the registration of projects and programs, as well as the verification and issuance of mitigation outcomes. You can rely in existing schemes. For example, gold standard saying, I just consider the registration process of gold standard, so I will allow gold standard to generate units as an ITMO for my host country. You can say also 6.4. But there are some bilateral agreement between which you don't have this interaction of specific standards. If not, you need to set up your own verification process, your own issuance process, and all of that to ensure that the units are real and meet the guidance when it comes to the definition of ITMOs. You need also to put on place the procedures for the authorization, how the authorization will be provided, what will be the timing, the authorization to set up projects and start the process, the authorization of the effective transfer of mitigation outcomes with corresponding adjustment. All those ones need to be set up by the host country. You need also to see how you will apply the corresponding adjustment. You need also to define, as I said, how the issue of corresponding adjustment will be linked with the unconditional or conditional NDC. That are some issues that we will need to address. You will also need to put on place all the procedures for the MRV, for the authorized ITMOs, and the tracking of all of that, because you need to report back on that. You need to have the registry, as I said, for the tracking. Also the database to apply this corresponding adjustment and provide the information to the international database. You will need also to have the reporting in relation to the centralized accounting and reporting platform. Just to let you know that there are many work to be done at the country level to meet first the participation responsibility, meet the guidance for the authorization and the application of the corresponding adjustment, as well as the tracking and reporting. And also all those technical issues I talk about to be ensured that within the country, you have this inclusive institutional arrangement involving many stakeholders to ensure that you meet the rules and you are meeting the interests of the country. That are some initial thoughts in that issue, and ready to discuss deeper this issue of authorization. Thank you.
Great, thank you very much for that, Mbaye. I mean, I think one of the things which I take away, and hopefully everyone takes away from that, is this isn't a continuation from what we've had in the past. There's kind of real different elements to using Article 6 from what countries had under the CDM when they approved projects. And so there is a real step change here. And Lambert, coming to you now. So after the end of COP26, you wrote an analysis of the Article 6 outcome, what it means in practice. And I think one of the things that you concluded in that was that how Article 6 is used will matter a lot. It's not sufficient just to rely on the rules alone. And it'd be great to hear from you a little bit more about what good use looks like and how that can be enabled now that we have the rules in place.
Yeah, thank you very much, Hugh. First, maybe I very much agree with you. I think the new rules under Article 6 are really a paradigm shift, and they are that in many ways. I think, as Mbaye said, the first point is countries, if credits are authorized under Article 6, always need to do corresponding adjustments, whether it's inside or outside the scope, right? And that principle is really important, because corresponding adjustments implicitly mean that countries give away their emission budget, right? And several issues conclude from that. I think the first one is that countries should kind of really need to carefully consider what projects they authorized, right? The project should really go beyond what they can do, and they should be clearly additional, because if they authorize something that happens anyway, they give away emission rights to someone else, and it becomes harder for them to achieve their NDC, or they may be overselling. And so I think that's a big paradigm shift. And countries, I think it's really, I mean, of course, it's up to countries really to decide what they authorize, but I think they really need to make a plan and think about their long-term strategy and their NDC. Okay, what are the policies and measures I have in place, and what is what I can achieve with these policies and measures domestically, and then maybe what goes beyond that, and through what measures I want to implement with carbon market approaches, right? So that really needs a strategy and careful thinking, not to run in the risk of overselling. I think another key principle, and that's a bit hidden in Article 6, but another key principle is that the mitigation outcomes should be shared, and that's implicit in many ways. One principle is that baselines should be set really ambitious, below business as usual, etc. And I think one idea behind that ambition is that part of the emission reductions can be used by the country to achieve its own NDC, and only part of them are internationally transferred. And how does that work? Like, if you have an ambitious baseline, and if you really set the baseline ambitious, basically you only credit part of the emission reductions, and those are internationally transferred. And the remainder, they will show up in the national GHG inventory. And so the country can use the other part to achieve its NDC. Because for many countries have formulated this objective, we want to use carbon markets to achieve our NDC. And if you want to achieve that, you need to make sure that part of the emission reductions can actually be used by the country to achieve its NDC. So I think that's another key consideration in thinking how to use international carbon markets in this new area under Article 6. I think when it comes to accounting, one of the issues I also flagged in my analysis is that, as Mbaye said, we have these two approaches, like a trajectory or averaging, to deal with single year targets, right? And they have a lot of implications, because it really depends how many, under averaging, how many units you can transfer or how many you need to acquire depends on the particular circumstances in the target year. If you're slightly off, or if you're a lot off in the target year, then maybe you oversell a lot. So there's a lot of risk with averaging, because how many units you can sell or how many you need to acquire may depend on the weather conditions in the target year, whether you have a lot of rainfall and hydropower generation or not, etc. That's the mechanics of how averaging works. And so that's also something to carefully consider, I think, for both buyers and sellers, whether that method really works well or whether it poses risks. And so an alternative there is establishing multi-year trajectories for accounting purposes, which of course it also matters how you establish such a trajectory, right? Whether that's a reasonable line that represents how you intend to achieve your NDC, or whether it's something flurry, right? So I think these are some of the important challenges. And then lastly, I think there are a number of new principles also, like overall mitigation in global emissions, the share of proceeds, which is mandatory under 6.4, but strongly encouraged under 6.2. So I think the expectation is that these two principles would be applied across all transactions, both under 6.2 and under 6.4. And so these are also really new elements which both buyers and sellers need to take into account and need to make choices on. Maybe I stop here so that we have enough time for questions later on. Thank you.
Great. Thank you very much, Lambert. And yeah, just on that note, if anyone has any questions as you're listening to the speakers, please feel free to write them in the chat box as we go, and then we'll pick those questions up later on in the session. But turning down now to Marisa, we've heard a lot from Mbaye and Lambert there about kind of the government perspective, and it'd be really interesting, I think, also in the session to focus on the perspective of the private sector, so those who are trying to invest in activities under Article 6. And Pollination with IETA last year led a study which looked at some of the legal gaps in the earlier draft versions of the Article 6 rules and some of the risks which are involved in investing under Article 6. And it'd be great to hear from you on, when you look at the final version of the Article 6 text, do the kind of conclusions from the early reports still stand up? And what are the risks that remain for the private sector looking to invest under Article 6?
Sure. Well, thank you very much, Hugh, and very happy to be here. Thanks for inviting me. So as Hugh mentioned, we have been working at Pollination on Article 6 related issues. And in particular, we did that legal risks analysis for Article 6.2 with IETA. It was published in May of last year. And in that, we did identify legal risks related to transacting Article 6.2 transactions. And it was based on the draft guidance, as Hugh mentioned. So some things have changed, and I thought it might be useful just to run through some of the risks that we identified, and then we can specifically talk about some of the changes with the final guidance. I will say it won't be an exhaustive list. You could look at the publication to see the full list of risks. But the first risk that we identified relates to authorization, which is obviously the topic of this panel, and clearly a risk that any seller, private or sovereign, would need to have the mitigation outcomes authorized by the country to make the mitigation outcome become an ITMO. And we heard from the prior panelist about all the things that need to happen to have the authorization process completed. And I think right now the biggest risk is that countries are at varying processes of getting that Article 6 governance completed, and that authorization process is pretty unclear. And so there's a risk that the sellers will have to navigate that process when it's completed, and buyers will need to understand that process as well to be able to do their diligence on whether the seller has the right authorization. So that's one risk that we identified. And that risk really was in the draft guidance as well as the final guidance. It didn't really change that. I think that, and that risk, I think, will be mitigated as we move through the process and countries continue to develop their Article 6 governance. I will say countries that have very transparent and stable policies on authorization, I think will have a market advantage, to the extent that it is easier for buyers to diligence it and for sellers to navigate it. So that's one risk. Another risk that we identified relates to the corresponding adjustment, which is very connected to authorization. As we know, what's authorized needs to be adjusted. And the risk there, I think we identified, there's two sides of that risk. One about control of doing the adjustment, applying the adjustment, and one related to the timing of the adjustment. So on the control side, only Paris parties can make an adjustment. I mean, it's a Paris requirement. you report it under Paris and UNFCCC mechanisms, like the Article 6 database. You report it in your authorizations and your transfers in the annual reports, your BTRs, et cetera. And so these are all Paris obligations on the participating parties under Paris. So if you're a private seller and you're selling an authorized adjusted credit, you're selling something you don't have full control over doing everything you need to do to make it an authorized adjusted credit. And so there's a risk there that you need to also have a agreement and arrangement with the government and, help mitigate that risk, because the government is going to be the one that makes that adjustment. So that's on the control side of corresponding adjustments. Also on corresponding adjustments, it's just the timing of the adjustment. So we know an authorized mitigation outcome needs to be adjusted, but the timing of when that adjustment happens is not simultaneous with that transfer. And that presents a risk. And I think this is one area where the Glasgow final guidance changed it a little bit. It didn't change the risk that, there is still a timing gap between the transfer of an ITMO and the adjustment, but they introduced more flexibility in our view about when that adjustment can happen. And that is in the definition of first transfer, which for other international mitigation measures can be upon authorization. It can also be upon issuance, use, or cancellation, as specified by the participating party. And so in that change, those additional scenarios means that the country can decide when to make that adjustment, and it could push it out a little bit further. So that is one thing that where there's a risk there, where if you have a longer lag time, things can intervene between the transfer. And, the buyer could have used that credit, the year they bought it. The adjustment could happen many years later. I mean, it wouldn't be able to go into the next NDC period, but it could get close to that potentially. And that's another area that will just, remains to be seen about tracking when those adjustments happen. There is a lot of transparency. I mean, there will be a lot of emphasis on transparency on when first transfers happen, when authorizations happen, and you'll be able to see when the authorizations happen, even if the adjustments haven't happened. And so there will be a focus, I think, on looking through those transparency, the framework and the reports to make sure that, everyone is aligned with what's happening and when it's happening. And then the third risk I was going to mention is just related to the use and nature of the non-authorized credits. And so I think in Glasgow and before and after, there's a lot of discussion about just the impact of Article 6.2 on the voluntary market and what does that mean? And namely, so getting into the world of non-authorized credits, I think is one area that there is a risk to be managed, just to the extent that the claims around non-authorized credits that aren't adjusted and the nature of those credits needs to be understood and managed. And what I mean by that is, so as our prior panelist mentioned, when you have a non-authorized credit, when you have an authorized credit, the government's not going to be claiming that for their NDC. If you have a non-authorized credit, the government will be claiming that, and the buyer could also be claiming it for another purpose. And so what you're actually transferring in that case, what kind of claims you can make in that case, those are risks that need to be managed. And there are consumer rights, misleading consumer laws in different jurisdictions that could be applicable. There's initiatives out there, with certain rules that you can be a part of, that you have to make claims, can use credits in certain ways. So that's a risk to be managed. It's also the nature in the contract of the credit. So to date, the carbon markets have really operated on the premise that when you're transferring the right, you're transferring a property right from a seller to a buyer. The buyer has exclusive right to that credit. You're not peeling off different rights and letting people have different rights in different areas. And so with a non-authorized credit, if the government is claiming that towards its NDC and a buyer is making a different type of claim, it changes that nature of what you're contracting for. And that changes the nature of your contracts and the representation and warranties that you might be making related to that asset. And whether, and there's different local laws in different jurisdictions that could also influence that. But that's just something that's a change based on Article 6 that would need to be managed. And obviously, these are all issues. So those are some of the highlight, I guess, of the risks that we identified. And I don't want to say that these are all bare risks that, can't be mitigated. I think all of them can be mitigated we outlined some mitigation measures in the publication that could be a focus of a whole other panel. But I will say discussions like this would be very helpful, I think, to continue to understand the risks because of the fact that it will have an impact on all sorts of different credit transfers, Article 6.2, and just having discussions like this and having buyers and sellers and countries and market participants understand the risks, and then you can manage them and mitigate them, I think is an important factor to make sure that Article 6 is successful. So I think I'll leave it at that, Hugh, and then we can answer questions if people have it on that.
Thank you very much, Marisa. That's really helpful. And I think that is where you ended, I think is the important message to take from this, that there's risk inherent in everything which is new, and it's finding the ways to manage that effectively so that you can get to the opportunities which you have from Article 6. And Lisa, coming to you now, I guess on this point, so what we have right now with the Article 6 guidance adopted at COP26 is a legal text, a legal framework. And it'd be great to hear from you, in your perspective, both at Resilient and as IETA chair, a little bit more about what the private sector needs now to make Article 6 commercially viable at scale. So what needs to be layered on top of the framework that we already have?
Thanks very much, Hugh. And I will dovetail with Marisa. We're very much in line with our thinking on a number of things. But let me start with the context. If you keep in the back of your mind the basic principle that business abhors a vacuum and uncertainty, and capital will not flow where it is uncertain about its return and or safety. Those are important things to consider when we think about what we need to layer on top of Article 6. And then secondly, if you look at the change, the fundamental change that Article 6, the new texts have made, it really results in empowering the host country where the emission reductions are occurring in a way that's very beneficial for the host countries to have control over how their targets, their Paris targets and NDCs are met, but also in a way that might result in uncertainty for transactions. So it's that balance that we're going to try and achieve. And I'm going to highlight 4 categories that I think we need an overlay, some clarity of process or purpose. The first is in relation to the form of authorization. It's very possible in terms of how we get the authorization, so the process and the look of the authorization itself, that we could have 196 different forms of authorization. We could have every party coming up with their own way of saying, this is authorized for use, A, towards an NDC, B, towards another international mitigation purpose, or OIMP, and third, that non-authorization category. There could be a form of saying, no, this isn't authorized, so it's purely voluntary as well. So if we can standardize the form of authorization and have key elements for every host country to include, that will go a long way to mitigating the navigation and due diligence risk and differentiation about, do I have this right? Don't I have this right? In what we have in the form of authorization. I want to point out one interesting difference. By definition, in the context of Article 6.3 and in the text, an ITMO towards an NDC needs 2 countries to participate. And therefore, there may be 2 authorizations that may be required. And we have to look at precisely what those look like, how they dovetail with another international mitigation purpose, or OIMP. There's another entity like CORSIA or the IMO, or potentially a corporate that needs to provide certainty for those ultimate corresponding adjustments that need to occur. So process and form for the authorizations, and then let's talk about non-authorizations. One would think that if a country simply says nothing, then it would be clear that it wasn't authorized. The risk for business in a transaction is 2 years into the term of a 10-year agreement, a country could subsequently say, actually, these are now authorized. And so you no longer have a voluntary instrument that you're transacting. So it may be that business wants an express form of non-authorization, i.e. a confirmation that these are voluntary for the term of this project. And that will go a long way to mitigating the uncertainty as to whether we're going to have a change of law or some other change that effectively takes those otherwise voluntary emission reductions into the realm of an NDC or an OIMP authorization. So that's the second piece. Third, on timing. We really have three elements of timing that could be very much in need of greater clarification. And again, in that broader context, business not liking uncertainty, we want the corresponding adjustment, the finalization, the crystallization of the ITMO as soon as possible. The way the rules are currently written, particularly for authorized for use for other international mitigation purposes, you could have a contingent liability on your books for up to a decade or more while you're waiting for someone to use the ITMO and have it reflected in a corresponding adjustment. So pushing the system towards upfront recognition, reporting, and corresponding adjustments will go a long way to facilitate business certainty, scale, and the power of the mechanism. And so when we look to that, it might be that we want to layer on top of the first transfer definition some rules that encourage that to be on issuance or authorization, and not so much on cancellation or use. That certainly could leave an entity with a contingent liability as opposed to an asset many years out. And that gets played through into the process and timing of the reporting. Do we want the corresponding adjustment and or the issuance of the ITMO by the host country reflected in the annual Article 6 report, as is contemplated, in the national inventory report of the country immediately after it occurs, in the immediate biennial transparency report, and not solely having to wait for the biennial transparency report that occurs after the end of the NDC compliance period. As soon as we can get those in a permanent, irreversible format, it will enhance market certainty. So I think those are three main things that could be done over top of the emission rules to facilitate smart scaling and ambition in a way that really promotes environmental integrity. The fourth one is a little bit of, for the lawyers who are a little OCD in the crowd, Article 1 or Section 1 of the Annex 1 lists the eligibility criteria for what can and cannot constitute an ITMO. And there's a list without any punctuation in between it. There's no ands or ors. And it's very apparent that an ITMO can't be two of those things, part of the list of two of those things at the same time. So we need some tidying on the text itself. And that will also be helpful to avoid double counting and ensure that we've got some clear rules throughout. So at a very high level, Hugh, that's what we'd love to see overlaid on top of what we've got in the text to date. And having been in the room, I can tell you it was tough getting there. Very tough getting there. So there's an ounce of congratulations. Yeah. There's empowerment, but we need that certainty.
Yeah, great. That's really helpful. Thanks so much, Lisa. I see that we've had a huge number of questions coming through, which is fantastic. Before we get to those questions, I just wanted to do a couple of things. Firstly, I fear that we've fallen into the trap when you talk about Article 6 of getting deep into the technical weeds, which is very hard not to do around Article 6, and then also focusing on a lot on the risk, which is partly in how we've kind of structured it here. And I think before we kind of move forward, it would be helpful just to remind ourselves of why this is there and why Article 6 is important. And I guess there are values, there are benefits for countries, there are for project developers, there are reasons why you would want to be engaged in Article 6. And it'd be really helpful to hear a little bit from anyone on the panel who wants to take this up on the kind of why, what are the benefits? And then also, if anyone wants to respond to anything which your fellow panelists have said, please feel free to do so now as well. And then we'll get into the questions after that. Mbaye, over to you.
Yeah, very quickly, just before coming to the benefits from participating in Article 6, I just want to stress what was said by Lambert when it comes to share of proceed and overall mitigation in global emission. As he said, it's strongly party and stakeholders are strongly encouraged to apply those principles in Article 6.2. But I think it's my personal point of view, because of the benefit of the share of proceed, the contribution to adaptation, as well as the overall mitigation in global emission. Because of that benefit, in the long run, the basis or the standards will lead to that. Because I think countries as well as companies and different stakeholders will be more interested in the credibility of units that have applied those principles than units without those principles. As well as I think that also units with corresponding adjustment will in the long run have more value and credibility than the ones without this authorization. But this is my personal view. We'll see in the long run how this will work. But I thank Lambert for raising that issue. Also for Marisa, thank you for your thing and the risk you have provided. But just want to know, because you have provided that paper before the adoption of the Article 6, do you plan to update it based on what came from Glasgow? Just to get your views. And lastly, with Lisa, for this authorization and non-authorization ITMOs, the problem is that for non-authorization ITMO, the host country governance may not be involved in that because they don't know what's going on. A private company can deal with someone else without being known by the host country. And that happened now. It's why it will be very difficult to have an explicit form of this non-authorization mitigation outcome. But we can see how that can be addressed. But coming now to these benefits, I think many countries have a conditional and unconditional NDC, and many of them rely on the market as well as the climate finance to meet this unconditional, the conditional NDC, and that can lead to greater ambition globally, because we will have the many participation of many stakeholders, and also participating in Article 6 can lead to a better understanding on what's going on in different sectors, even if those sectors are not included in your NDC. And in the second NDC, you can include it and have a higher ambition in your NDCs, in the subsequent NDCs. And there are also all the issue of the MRV, the tracking, that can push a country in many sectors to put on place all this MRV to better understand and know what's going on in some sectors that are not taken into account in their NDC. That are some thought, but there are many other benefits in participating in Article 6. And also, you will have the linkage between the country's actors with the international market, as well as if you have some carbon pricing instruments, you can also use some outcome from Article 6 to offset, for example, a carbon tax or whatever. There are many benefits a country can have to meet its conditional as well as unconditional NDC. Thank you.
Great, thank you very much for that, Mbaye. Lisa, over to you.
Thanks very much. Let me first speak to the benefits piece. And I just want to point out a study was done by IETA and the University of Maryland, where there was an actual quantification of the benefits of broadly cooperative mechanisms and the nature of Article 6 and what it can do for two things. Number one is ambition. It can significantly increase ambition in terms of the number of tons that might be achieved over the same period of time. 250 billion is the number that sticks on the top of my head, but don't quote me on the number. And then secondly is the cost. The cost savings is very significant. So I'm reminded of the old adage that says, if you want to go fast, go alone. But if you want to go far, go together. And we need to go far. We need deep and ambitious emission reductions across all member countries, all member parties, in order to meet the Paris targets. It is not an insignificant goal, so we have to cooperate and collaborate in order to do that. So from that perspective, Article 6 has significant benefits in the form of ambition and cost savings. Let me respond very briefly to Mbaye's question around unknowns in the country. Any business that now is prudent and is aware of the Article 6 rules has a contingency about doing something without the government knowing about it. They have a risk that 2 years hence the government can find out about it and say, this is now part of my NDC, or this is now authorized for an OIMP. And then you're left with a far different transaction, if any transaction, that you thought you had. And we're seeing that. Recently, Carbon Pulse reported that Indonesia's put effectively a hold on the export of its voluntary credits. And so we're looking at how we get ahead of that process and ask for express non-authorization. How do we get certainty in that process? Give me a document that says these are truly voluntary, and here's how we can claim the rights and the co-benefits, and how do they fit? Work out. I'm not sure if I got you there.
I think we may have lost signal for a little bit there, or I may have lost it on my side at least, but we caught most of that. So thanks for that, Lisa. Marisa, Lambert, is there anything you want to say on this point before we move on to the next questions in the chat?
Maybe I would like quickly to touch upon one point which came up in the chat and in the conversation, the difference between conditional and unconditional targets. I think many developing countries, some have set both targets, right? Mostly for the same sectors. And many countries have said, yes, we want to use markets to achieve our conditional NDC, which I think is fine. But I think it's really important to think how to do that, because I think, as I said earlier, the best way to do that is to share the emission reductions between the host country and the buyer, because that makes sure, okay, the host country can use part of the emission reductions to achieve its conditional NDC, and the other part is used by the buyer. And I think that's also how the text works, right? Because in the end, you have this structured summary, and you compare your adjusted emissions to targets, to both conditional and unconditional targets. I think it would be dangerous to go the route to say, okay, I don't need to do corresponding adjustments or anything, so I can go from my unconditional target to the conditional target, and then sell these emission reductions, and another country claims them to achieve its NDC. And because that could actually lead to double counting, in my view, because still an NDC is an NDC, whether it's conditional or unconditional. And if one country claims the same emission reduction to achieve its conditional NDC, and another country claims the same emission reductions to achieve its NDC, then this doesn't lead to more ambition, but to less ambition. So I think it's really careful how to design that. And I think it's really key that host countries can use part of their emission reductions to achieve their own NDC. And I think this is key for the objective of the mechanism. And that comes back to your question. I think the objective of the mechanisms under the Paris Agreement is clearly to raise ambition, not only to lower cost, but to raise ambition. And if you want to ensure that, you need to provide incentives for the countries, for both countries. For the buyer, it's quite clear they can increase ambition because they have access to further cost-effective mitigation, but also for the seller countries, if they can use part of the emission reductions to achieve their NDC, then they may be ready to step up to set ambitious conditional targets, etc. But if they can't use that part, then there's a perverse incentive for those countries to set targets less ambitiously in order to sell more credits in the future, or not to step up ambition of their NDCs. And so I see this as a risk and as a chance, right? So there's a risk that seller countries could set their targets less ambitiously, but there's also a chance if you design Article 6 well, so that they can use part of the emission reductions, that they don't have an incentive to do so. Thank you.
Great, thanks, Lambert. Marisa, anything to add?
Sure. Yeah, I think to your question on the benefit of Article 6, I think Lisa and Lambert and Mbaye have all covered it well. I think there's a huge benefit to using it. I think in my presentation, I did lay out a lot of the risks. And again, lawyers just do that. I think that's why we're annoying and don't get invited to things, because we lay out all the risks. But I think it's also an exciting time where we can identify the risks and manage the risks. So I think that's the sense. We have a lot of smart people working on this, and it's a moment where it could seem overwhelming now, because everything's evolving in many different avenues on the international level. There's domestic laws, there's contractual issues you have to deal with. There's lots of moving parts. But I think with the eye on using Article 6 to increase benefit, to ensure environmental integrity, as long as we have those guardrails and can use it appropriately and manage the risks that we identify, I think there's a large, huge benefit there that we could see using Article 6. So I think it's all there. And I don't want to overemphasize those risks, and I think they're all manageable again.
Great, thanks. I asked you about them as well, so it was unfair in making me make you highlight the risks of this. So thank you everyone for those inputs. I do want to turn now to some of the questions, because we've received lots of them in the chat box. And the first one we received was from Hannah Marie, which was about some of the experiences that we've already been able to generate under joint implementation under Kyoto. And there are some elements from joint implementation, the host country's role in avoiding double counting, setting stringent baselines, that we may be able to draw on from Article 6. So it'd be really interesting to hear from many of the panel on what are some of the key lessons from joint implementation. And if anyone wants to as well, maybe we can kind of extend beyond that and just highlight some of the key pieces we already got from the CDM or from other elements of market practices in the past, which can help us to get Article 6 moving quickly. I don't know if anyone wants to take this first.
Just let me highlight a difference in terms of the joint implementation process was based on the AAU, the Authorized Allowance Unit, and it budgetized in a way that's different than Paris all associated elements of what is now the NDC. So everything was effectively expressed as an AAU. We have things being referred to in the context of CO2 equivalents through the rules, but that's going to take some time, number one. And number two, we have ability to express in NDCs non-CO2 related targets, such as renewables, percentage of renewables, etc. So there are learnings in terms of avoidance of double counting, empowering the host country, facilitating clear reporting rules that get reflected in the compliance system in a way that's open, transparent, auditable. These are good things, but there are themes and differences that we have to account for in this new world as well.
Anyone else on this question?
Yeah, maybe I can quickly come in. I think there were two main lessons from JI. One is that the ambition of the country's targets really matters. So there were some really good projects, but there were also lots of hot air being sold from Ukraine and Russia in particular. And what we saw is that some projects really overestimated their emission reductions tremendously. They were very unlikely to be additional, etc. And I think the other lesson learned is that it may indeed help to use kind of rules that have been developed under other standards, like whether it's international rules or rules from a carbon crediting programs which have gone through expert panel reviews, and not to define kind of just methodologies for a specific project. What we also observed in JI is that there were sometimes methodologies being used for certain project types which were so unrealistic in the emission reductions. The emission reductions were much larger than the emissions which show up in the inventory, right? So, and that was partially because baselines were inflated through completely unrealistic assumptions. And I think a lot of that could have been avoided if kind of vetted methodologies through standards, through international processes would have been used. So I think the ambition of the host country and kind of use of international processes can help to mitigate some of these risks.
If you allow, what I can say also is not in relation to GI, but on the CDM, because we can learn a lot also on Article 6 from the CDM. One important issue will be about the methodologies. Bearing in mind that we have to take into account the host country's NDC and its long-term strategy, we can learn a lot from the existing CDM methodology to be refined in relation to that issue. We can also learn a lot when it comes to the additionality issue, to the crediting period. All those lessons we already had under the CDM, we can learn from that and refine the rules to be defined in relation to that for more ambition for this mechanism. What can be also learned from the CDM? We have already many accreditation procedures for DOE, for many other things. We can learn from that and see how we can align that, bearing in mind the most important role of the host country when it comes to the validation, to take into account the NDC and all of that, we can learn from that and see how we can refine those existing procedures, those existing standards we already have. And lastly, we can learn a lot on what have been done by the regional centers when it comes to this capacity building, because as you have learned, we need to set up a very robust capacity building program to support countries to set up their institutional arrangement, as well as participating effectively in many issues when it comes to designing the baselines, when it comes to additionality in the validation process. There will be more involvement of the host country. And the interaction we already have between the regional centers and the host countries' governments can be a basis to build on to have this institutional arrangement. That are some benefit we can get from the CDM when implementing this Article 6. Thank you.
Great, thanks, Mbaye. And this was actually one of the questions that received a few likes in the comment box, was about capacity building and the fact that there are institutional arrangements in place under the CDM in many countries, but there is a step up in what's needed for Article 6, and many of the ministries which would be dealing with this are underfunded. And I know that there was agreement around capacity building at COP26, and it'd be really helpful to hear from you and then from anyone else on what's been agreed so far around capacity building, what are the real needs, and then I'm interested in thoughts on needs beyond just governments, because there is a kind of at least in education, across not just governments, but also kind of other actors in the market as well, because this is a step change for many of us, standards included. So Mbaye first, and then anyone else after that.
We will need two levels of capacity building. The first one will be at the institutional arrangement, because as you know, there will be more involvement of the West country in many technical issues, in defining the baseline, in having this trajectory of the NDC, assessing project against the NDC, giving the authorization, and meeting the participation responsibility and all of that. We need this infrastructure, and it will be not just only from the Ministry of Environment. For example, in Senegal, we are starting to set up this standardized crediting framework in which we involve all main ministries, but also the private sector, NGOs, all stakeholders within a committee to address all these mitigation outcomes, to have the procedures and all of that. We need something more broader than just having a DNA as we had under the CDM. But also, as that is the institutional framework, but a part of this institutional framework, we need also to build the capacity of the different actors at the different levels, at the government level in this framework, but also the private sector to know what have changed, what need to be done, what we expect from their side, and all need to be done. So we have two parts, and what we have said, that was decided in Glasgow, but we want that to start immediately. We need to define within our negotiation and discussions that will come in the next month, starting with that and starting to build with the RCC what can be done to allow country to have the minimum requirement and minimum infrastructure in place and the minimum human capacity building need meet to start with the Article 6. That are some elements, but we are working on that, and I think we can, at the next year, start to have that in many countries. But because some pilots have been conducted first with the World Bank under the CDM, but also many pilots, including the GCM, the Switzerland, the Norway, Sweden, all of them have started to build this capacity building with the participating parties. Thank you.
Great, thanks, Mbaye. Anyone else on this question? I mean, Lisa, it's a slightly different question, but I guess Lisa, Marisa, I'm guessing that you've had a lot of questions from clients in the aftermath of Article 6 about what this means in practice, and it'd be really helpful to hear from you. I suppose not so much capacity building in the form of what governments need, but what you think are the main unanswered questions, and where across the market there needs to be a bit of a renewed understanding of what the world looks like now we have Article 6 in place.
I think that that's right. In terms of the capacity building in the business community, there are a few things that are converging, and one is with a focus on environmental integrity. What do we need to do at a high level to ensure that what is intended to go on as a voluntary transaction or as an Article 6 transaction continues to meet high levels of environmental integrity? And then secondly, in terms of how do the standards interact with the business community and help bring them along? And that's a very important part. And you'll see that will trickle down to the contracts themselves. And Marisa touched upon the point around, if we think we're transacting in a voluntary unit now, we have to be very clear about what rights are and are not in that unit and what might change over time as the host country continues to develop capacity and understanding and evolve, particularly over NDC compliance periods. We do expect more ambition in accordance with Articles 4, 12, and 13 out of those successive NDCs. So from that perspective, I think there's a lot that needs to be done, not just in the traditional voluntary market, but also in the non-UNFCCC markets, including CORSIA and the IMO and other like entities that will play into a parallel market.
And I'll just add, I think we definitely are getting a lot of questions on what is being transferred and what you can use and what the claims you can make about what the credit is you're buying. And I think part of this is, you know, a lot of people went to COP, you know, there's tens of thousands of people who went to COP with a couple thousand in the negotiating room, right? A lot of people around the edges. But a lot of those people aren't looking at the negotiating text. It's hard to decipher. They may not understand it. You know, like, what does that mean? And then at the same time, they're continuing to transact in voluntary credits, thinking that those worlds are entirely separate. And I think that is what's changed, I think, with a lot of discussions that we've been having with folks, is that there's better understanding now that there is an implication for even the voluntary credits, because, and then a better understanding about the claims you can make on adjusted or non-adjusted credits. And that concept of adjustment has been around, but I think it's just heightened and become more, there's more of a spotlight on it now, obviously, that the guidance has been finalized. And so then when you try to put that into a contract, that's where it really becomes crystallized, I think, where people really have to understand what it is they're buying, what they're selling, what claims they can make. And then people who are going into these longer term contracts where the Article 6 governance may not be up there now, but will be throughout the term of that contract, need to think through like how the contract would need to be adjusted and what provisions to put in there to account for that. And so I think people, the understanding is becoming more sophisticated, which is great, because I don't think people want to do the wrong thing. I think a lot of the corporates and the buyers and sellers, they all want to do the right thing. It's just getting a better understanding of what that is and, you know, what can they do with it. And it is a big change from what we've seen to date. So for the folks who have been in the market for a long time, it's a bit of a sea change on what you can do with the credits, but not entirely. A lot of the constructs are still there, just around the edges. And then, you know, ITMO versus authorization and non-authorization. And then if the countries don't have their authorizations set up, it's even harder to understand how to do that. So I think we're at this moment of transition where it'll become more clear, and we just have to get through this transition in a way where we're not undermining Article 6, because there's so much pressure on Article 6. We want to make sure we get through it and can use it the way it's intended to be used.
Great. That was really well put. Thank you for that. I think we've got time for one more question from the chat, and there's many questions we didn't get to. So for those that we didn't, where we can, I think within Gold Standard, we'll try to, where they're factual ones, we'll try to provide some answers in follow-up to all participants. And I'm sorry to those we haven't been able to get to. But one of the questions that's received a few likes as well gets to an issue which is we've been scratching our heads in Gold Standard about the best way to manage this, and it's the question of what happens if, I suppose, host countries don't do what they're meant to. So the kind of natural consequence of what's there in Article 6 is if you provide a letter of authorization, you must then apply a corresponding adjustment, and you must adjust for the emission reductions you've authorized. But what happens if that doesn't take place? So you have an authorization and then the adjustment doesn't happen later. And where does that risk sit if you have private entities who are involved? And this is something that we've been thinking about, but I'm sure that others have as well. And I don't know if Marisa, you want to say anything from the work which you did last year, Lisa, or anyone else wants to comment on this quickly?
Sure, I could start. I think it's a great question, and it, you know, it hasn't happened yet, so we don't know exactly. But from our reading of the guidance and our discussion through the IETA publication, where we had an expert panel who participated in, you know, reviewing the publication, and we had a good discussion about it, I think there's an understanding of, if the corresponding adjustment doesn't happen, if the credit's authorized and it's been authorized through the correct processes and it's been transferred, that credit is valid. That credit has been authorized and is an ITMO. If the adjustment doesn't happen separately, that's an issue between the country and Paris, you know, the Paris compliance requirements. It doesn't go back, it doesn't cancel that credit that's already been transferred. and it doesn't claw back the credit. It doesn't do anything like that. So that's our working knowledge of what that is. Because if you did have that clawback, if that adjustment didn't happen, that would be very messy for the market, I think, to be able to manage. That said, if the adjustment doesn't happen, it's not like everything's great. I mean, the adjustment should happen. There should be some consequences for the adjustment not happening. And a buyer who's continuing to buy credits that are continually not adjusted could have a risk of reputational risk or otherwise, and be seen as, you know, buying credits from someone who they know is not going to be adjusted. Like there could be some risks around that, but the actual credit itself, in our view, I think would not be affected. It would just be some issues around the edge, and then the party would have issues, you know, vis-a-vis the Paris compliance provisions. That's our view. Lisa, Lambert, I don't know if you have other views on that.
Let me just wade in a little bit in terms of the ITMO that goes towards an NDC. Our view is that clearly that requires two parties authorizations. There has to be two parties. One, the first transfer country, and the country authorizing by definition under Article 6.3. So that mitigates some of that risk. But in the situation where you've got authorized for use towards an NDC, towards an other international mitigation purpose, then you've got an entity and a country that have to adjust. So I would agree with the fact that it's not read as a clawback. However, I think there are encouraged, particularly on the first time that you're dealing with a country in a cooperative approach, to maintain a buffer, some semblance of a buffer. And in that regard, this is in the country of use, not through the standard or others. In that regard, there can be some sort of interplay and bilateral dispute resolution mechanisms between the two countries or the country and the entity if the corresponding adjustment doesn't occur. But to put the risk back on the market participants who diligently got that authorization, relied on that authorization, did so to their detriment, I can see a very strong legal claim there in around the legal legitimate expectations or negligent misrepresentation if that doesn't happen. So we have to look again at the privileges and immunities of sovereigns, which are decreasing as a function of the IFC and JAMS case. And we have to look at how that will work out between the countries. But I would definitely agree with Marisa. There will not be a clawback. There may be mechanisms to A, proactively mitigate, and B, provide for dispute resolution among the offending entities, country and entity or country and country, if that occurs.
Maybe just a few words. I think the Article 6 text is really clear that if you have provided an authorization as a country, you have an obligation to do the corresponding adjustment. It's not a possibility, it's a shall, right? So you are free to decide whether you authorize, but once you have done so, you have the obligation. And if countries wouldn't do so, this would kind of be detected in the review. We have an Article 6 review and an Article 13 review. And then that would be escalated through the review. So it would be, ultimately, it would find its way in an Article 13 review report from the review expert team under the enhanced transparency framework. And then it would be considered in the multilateral consideration of the parties' progress on NDCs and would be discussed there. Of course, we know that the compliance mechanism is non-punitive, facilitative, etc. So in the end, there are no sanctions to the country, but I think a country not following up on its corresponding adjustment would face a lot of international pressure and reputational risk. I think maybe one bigger risk even is what happens if a country leaves the Paris Agreement and it has authorized before carbon credits, right? I mean, that's another scenario which is imaginable. A country authorizes units for CORSIA or for voluntary purposes, for other international mediation purposes, and then it leaves the Paris Agreement. And then, of course, it has no longer obligations under the Paris Agreement. It doesn't need to submit a biannual transparency report, etc. So there are also other scenarios where there are problems. It's really hard to solve them, I think, but these are certainly risks.
Just to say, we've experienced that live within the Western Climate Initiative regional program. And that has given rise to dispute resolution under the North American Free Trade Agreement, as it then was, and now it would be the US, Mexico, Canada Free Trade Agreement. So there are precedents. This has happened, even though this seems new and novel. It's been traversed in other forums before.
Over to Mbaye, and then we're going to close out after that. Oh, you're on mute, Mbaye.
Just to add very quickly something, is that we are still working on the rules about the Article 6 review and the review under the Article 6. And I think some additional provisions need to be put on place if a country doesn't meet whether the participation responsibility as well as the requirement under Article 6. I don't think while the Paris Agreement itself is non-punitive and you just make recommendation and parties do whatever they want, that need, in my personal point of view, need to be different when it comes to the review under the Article 6 review. And the outcome of that review need to be addressed differently than the outcome from the Article 13 review. But it's a personal point of view that need further discussions when we come to that. Thank you.
Thank you, Mbaye. And we've come to the end of the time we have allocated for this. So I just wanted to say thank you very much to all of the panel for this. So thank you to Marisa, to Lisa, to Lambert, to Mbaye, and thanks to everyone as well who was listening into this, who asked questions. I think in a way we failed in our objective here, and that we've left unanswered more questions than we were able to answer. But hopefully everyone has found this useful, that there's a lot to dig into, but we try to expose this as well, why it's important that we do. There are real benefits for countries for what we're all trying to do here in getting closer to net zero and achieving the goals of the Paris Agreement if we get Article 6 right. And that's what we're all trying to work towards. So thank you very much for this. This is the first in a series of panels and webinars that we at Gold Standard are organising this year to try to dig into the implementation of Article 6 a bit more. So we're going to share information with all of those who've registered for this afterwards on the panels which we've got coming up. The next one is in April and is focusing a bit more on how host countries are starting to prepare for Article 6, which will get into some of the questions we couldn't answer in this session here. So thank you very much to everyone. We'll follow up afterwards with a recording with information on what comes next. And I wish you all a good rest of your day. Thank you very much.